So today's topic, how does an unopposed divorce work? So what do I mean by an unopposed divorce? Let's maybe look at the issue of what is an opposed divorce, and then we can compare the two. An opposed divorce would be a situation where one party wants to get divorced, he or she proceeds with the divorce process, drafts a summons starting the divorce process, asks for certain things in the divorce documentation. For example, he or she wants to have custody over the minor children, primary care, wants X amount of child maintenance, and maybe wants more than he or she is entitled to propriety wise. Whatever the case may be. The other party is not happy with that, the other spouse, and that spouse now decides to defend the divorce with a counterclaim whereby he or she will say, I want the following. So the divorce is obviously opposed. The parties cannot come to an agreement regarding the divorce. Maybe they can come to agreement on principle with the aspect of the divorce, but not the other aspects. For example, the children, property, maintenance for the one spouse, and so on. So that's an opposed divorce that can only be resolved with a trial where the judge or the magistrate will hear oral evidence. The wife will come on the witness stand if she's a plaintiff, and she will explain to the court what she wants, why she wants it, and so on. And be cross-examined by the other side's lawyer or by the other side, and the opposite will also apply, whereby the husband will come on the witness stand and he'll explain what he wants, why he wants it, etc. And then ultimately the judge will make a decision. So that's a opposed divorce. Obviously, there are many more steps involved, like discovery and pre-trial, etc. So we're not dealing with that now. So I'll compare that to an unopposed divorce. And an unopposed divorce is simple. The parties are in agreement that the parties need to get divorced. They agree upon everything, child custody, child maintenance, the property aspects, which should not really be argued over because people should know what they got themselves into or what matrimonial property regime applies to them, and that's what the law says. So they agree upon everything and they proceed with the divorce on an undefended or unopposed basis. One party will still have to issue the summons, serve it on the other party, but the other party would not defend it, and the matter will proceed smoothly with no opposition. Obviously, the court will make a final order, a decree of divorce incorporating whatever agreement or whatever was stipulated in the divorce paperwork. If certain things were not properly done, for example, there's a pension fund and you never properly stipulated that one spouse is entitled to the pension fund, then you'll have some difficulties in the sense of you'll have to approach the court again later on and ask the court, please give me a clause, is make an order that the pension fund should pay the one spouse his or her half of the pension. So those are important things to note when you're dealing with the legalities of a divorce. If you know what you're doing, great. If you do not know what you're doing, make use of an attorney or an advocate to assist you in that regard. On the screen, I have provided a few simple steps. Obviously, there are some, could potentially be some additional steps. Hopefully, I'll be able to mention them, what applies to an unopposed divorce. But the procedure is generally straightforward. Many attorneys or advocates provide the service, many at a fixed fee or at a general fee, with certain disbursements, certain costs that are obviously included. For example, the sheriff will charge a certain fee to serve the summons on the other party. So that's a fee you cannot get past. The court itself does not charge anything for their services. So that's great. Back in the day, but maybe 10 or so years ago, you had to have revenue stamps to start a legal process. The last time they stopped at 80 Rand. You have to put stamps onto the summons, and they'll provide you a case number. They'll stamp the document for you. But that's no longer the case. So courts are totally free, which I think is great. Okay, so let's apply the scenario. Husband and wife, they want to get divorced. They sit on the same table. They say, they want to get divorced. They agreed upon everything. The child will stay with the mom. I'm using the stereotype examples. They can even agree that the child should go with the father. They have agreed upon what visitation rights should be given to the father every second weekend, maybe midweek contact, or they could have agreed to 50-50, shared care, where the child is 1 week with the father and 1 week with the mother. Alternatively, maybe 3 on, 3 off, 2 on, 2 off, and so on. So where the child is half the time with each parent. They agree upon the amount of child maintenance that the parent would pay, or they agree that parent should pay no child maintenance because that parent cannot afford it, whatever the circumstances are. And they deal with issue concerning personal maintenance or alimony. They might say, wife, she says, I'm working, the husband is working, he or she does not want anything from the other side. So that's great. They resolve that issue. And the proprietary consequences, they know that they are married income with a property and they know the joint estate will have to be divided. There's a pension fund, there's a house maybe, whatever the case may be, and those things will have to be resolved. And they deal with it quite well in their documentation. So when they do get a decree of divorce incorporating that settlement agreement, there will be no problems afterwards. Or it could be a scenario with a young couple, with only a child, there is no pension fund, there is no house, and things are very simple, there is no debt, whatever the case may be. Or the other example would be they are married out of community property without the accrual regime, meaning they leave the marriage with whatever they have. There's no duty to pay the other party any part of either party's estate. If they are married with the accrual regime, there could be a bit of challenges regarding determining what the accrual is, who made more money during the marriage. I like using that example. At the start of the marriage, they were worth so much. The wife became very wealthy and she built an empire and she's really wealthy now. The husband is still where he was. So she'll have to pay him out something in terms of the accrual. That's where I'm saying understand the law because you may want to save some money in not making use of a lawyer, but you might lose out a huge amount of money ultimately if the legalities aren't properly done, especially when it comes to issue concerning accrual and pension funds. Regarding the houses, those are very simple things to do. The house is sold and you share the profits. Generally, that is the case. So you're sitting on the table still and you discuss all those issues. You discuss who will become the plaintiff, who will start the legal process, and who will be the defendant. So usually it's the one that's a bit more stronger in personality that will decide he or she will be the plaintiff to start the legal process. And generally it's a plaintiff who appears in court on the date of the divorce to give evidence. Of course, the judge will have to know, has the marriage broken down? Are there any kids? Can the marriage be saved, etc.? And that's where the oral evidence come in. It's not like some countries where they say you can just sign a document and get divorced. No, only a judge or a magistrate can divorce you, and you have to appear before the judge. One party should at least appear before the judge and give oral evidence. So you've agreed upon everything on the table. Great. You decided you will be moving out. That does not necessarily have to be on the divorce settlement, but you've come to those type of agreements. Child maintenance as well, etc., as I mentioned earlier on. Okay, so let's look at the whiteboard on the screen. There are a few ways. This is one of them. There is obviously a few ways to do it. One way would be you do not enter into a settlement agreement before the time. All the terms which the party wants would be in the summons or in the particulars of claim, and the other party will just do nothing. And when you appear in court, ultimately the court would make an order based upon the particulars or the summons. I do not like that approach. I like the parties to sign something, and because after the divorce, they walk around with a settlement agreement that was made in order of court, or a consent paper, or parenting plan, depending what the issues are. So point number one, both parties must agree on the terms of the divorce. We dealt with that just now. A settlement agreement gets entered into dealing with property aspects of the marriage. Who gets what happens to the house, what happens to the car, what happens to the pension fund, all those things. Just one point, sometimes people agree that you can keep your entire pension fund and I will keep my entire pension fund. Or we have two houses, you keep one house, I keep one house. Or we sell the house and you only pay me out 20% as opposed to the 80%, whatever the case may be. Or you retain the house and you pay me out. That's the property aspects. And be the children if applicable. Okay, as we mentioned earlier on, custody, contact rights, etc. So that is dealt with in the separate document. It can be dealt in the consent paper in a settlement agreement, but I prefer to deal with it in a parenting plan. So when there are disputes, you do not walk around with with a a thick document dealing with property issues, pension, etc. And somewhere at the back, we're dealing with care and contact. So we'll have a separate document dealing with care and contact. And the same way, we're dealing with property issues after the divorce, you have certain problems. You're not giving the pension fund a document where half the document deals with care and contact. So you separate the two, but it can be dealt with in one page, in one document, a settlement agreement or a consent paper. So that's great. Then or your attorney would draft a summons and attach thereto. A summons, of course, will have a particulars of claim explaining who the parties are, the date of the marriage, the reasons for the breakdown of the marriage. You'll refer to the settlement agreement consent paper, which you'll be attaching to it. But to the divorce documents or part of the divorce documents or part of the summons, there will be a consent paper or settlement agreement or parenting plan, depending upon whatever the parties make use of. And that will obviously be issued at court. You'll go with a few copies. The court will stamp it, give it a case number, and then that specific summons or bundle of documentation will be taken to the office of the sheriff, where the other parent, the defendant in this case, resides or works, and the sheriff will serve this documentation on the other parent, on the other party. Now, this is where at the point where the divorce will officially become unopposed, because we expect the other parent to do nothing, not to oppose it, because in the summons it says if the other parent or the other party, not necessarily parent because there might not be no kids involved, but the other spouse does not, sorry, if the other spouse wishes to oppose the divorce, he or she must file a notice of intention to defend. So that is outlined in the summons. And the reason for that is, how do we know that that consent paper that's attached to the summons is legitimate or was agreed upon? It could be an outdated document. There might have been a more recent one that came out afterwards. So it still needs to be served upon the other party. The other party has a right to decide to oppose it. And he might have changed his mind as well, or she might have changed her mind as well. And then a period of at least 2 weeks, 10 days, 10 court days will have to elapse. And if the parent who was served, the defendant in our example, does nothing about the matter, received the summons, and is happy with what the summons stipulates, he's happy that the consent paper attached thereto is fair and he signed it, the parenting plan is fair and he signed it and is happy with that, and he does nothing for 10 days in the High Court at least, then the plaintiff, in our example, the wife, she is allowed to set the matter down for an unopposed divorce hearing because the matter is now unopposed. The 10 days has expired for the party to decide whether or not he or she is defending the matter, he or she done nothing, set the matter down for unopposed divorce. Okay, so here the things become a bit more not challenging at all. But because of COVID-19 and the courts limiting the amount of people that were inside the courts, you might have to wait some time to get a court date. For example, in the Western Cape High Court, I applied for a date last week and I was lucky to get a date just over a month from last week. In the magistrates courts, depending upon the magistrates court, there are many around. Some might have early dates, some might have but later dates. My guess is as good as your guess, and you will have to determine that specific courts availability of dates. Maybe what you're watching this video in 2023 or 24, and the facts might be totally different. But before lockdown, I would have waited the 10 days, and I would have set the matter down on the unopposed divorce roll usually a week later after the 10 days had expired. And so the whole process would take about 3 to 4 weeks to be finalized. So where are we? We are now still at point number 4. The summons gets served on the other spouse. Point number 5, the matter is not defended and it's set down for hearing. So you set the matter down for hearing on the unopposed divorce roll. Number 6, the agreement regarding the children is endorsed by the Office of the Family Advocate. Very important. If there are minor children involved, the Office of the Family Advocate would have to study this documentation, the settlement agreement, consent paper, or parenting plan to determine has the best interest of the minor children been attended to in the settlement agreement. Usually, I mean, not usually, it's a requirement. When parties get divorced, they have to file an Annexure A dealing with various aspects of the parties, the income, the children, the school they attend to, disabilities, whatever they may have. And that would assist the family advocate to look at the divorce documentation and determine what is it in the child's best interest. For example, if the consent paper or the parenting plan or settlement agreement says that the one parent is not allowed to have any contact with the minor children at all, or only contact once a year, I'm using a very extreme example, that might be a red flag for the Office of the Family Advocate, and he or she might want to comment on it and ask the court to hear oral evidence regarding that. Or there might be a clause stipulating that no maintenance is payable. The family advocate might want to raise a red flag, and that must be obviously be dealt with, etc. So that's a role of the Office of the Family Advocate to ensure that looking at the documentation, obviously it's dead paper. There is no other version from the other side. They have not filed any documentation, but based upon that, the Office of the Family Advocate will have to determine. But 9 out of 10 or 99 out of 100 times, if the consent paper is general in the sense of maintenance is payable, a reasonable amount of money, contact by the one parent could be every second weekend, of the school holidays, a standard reasonable contact, there would not be any issues. Then we're dealing with the most important aspect where things get finalized. Point number 7. On the hearing date, a party would give evidence and the divorce is granted. Okay, so with the matter set down, there are a few things which the court will have to determine before the court would divorce you. The first one, the court would have to determine whether or not that is you. Are you the plaintiff or you are the defendant? After you're on the witness stand, of course, having sworn yourself in. Then the court would have to determine, do you consider the Western Cape as a permanent home or the specific province or the specific area as a permanent home, or are you domiciled here or a resident here, whatever the case may be. It's a requirement that is in the sense of we cannot divorce people who aren't living within our area or jurisdiction. It's very, very important. If you live in Johannesburg and the post parcels are living in Johannesburg, you can't have a holiday here in Cape Town quickly, fly down to Cape Town, issue divorce summons, and decide to get divorced in Cape Town. No, you'll have to get divorced in Gauteng. The court will obviously want to determine whether or not the parties are married. It's an important question. You can't divorce people that are not married or divorced already. That is where you bring a copy of your marriage certificate, whether original or certified copy, and show the court, yes, we are married, and this is a copy of a marriage certificate. So that's fine. The court want to determine whether or not there are minor children involved as well. So you have to testify, yes, judge, there are minor children involved. There are two, or there were minor children involved, or we have no minor children involved because they're all now adults, they're all 18 plus. That's also fine. So remember, if the kids are 18 plus, we do not deal with them in this divorce proceedings. You stipulate in the court documentation there are no minor children involved. Then, of course, the court does not want to divorce happily married people. The court would have to be convinced that the marriage has broken down irretrievably. The marriage cannot be saved, and your attorney or you will testify and say, the marriage has broken down. There's no love and affection, no communication. You live in separate homes, whatever the case may be. You're argumentative. There's assault. I do not know. Whatever you want to do, you do not necessarily have to display all your, as I say, dirty laundry because the matter is unopposed. The court will grant you the divorce in any event. And the court would obviously want to verify certain things. The court sees in front of him a dead piece of paper, a consent paper, settlement agreement with some signatures on there. And the court will ask you, or your lawyer will present to you for you to confirm, is that your the consent paper, whose signature is next to your name, whose signature next to the other party's name. You're going to have to verify this for the authenticity, for the to make the documentation authentic in that specific sense. And if the court is obviously now convinced that the documents are authentic, that those are the signatures of the parties and it's legitimate, etc., the court will be happy and satisfied. And ultimately, the last question or last comment that the lawyer or you will do or ask the court is you'll ask the court for a decree of divorce, incorporating the terms of your consent paper, settlement agreement, or parenting plan, and that's it. And the judge will usually say he's satisfied or she's satisfied that the marriage has to be broken down and will grant a decree of divorce incorporating the terms of the settlement agreement, consent paper, or parenting plan. And then that's it. Next matter gets called up and the same procedure gets followed. The files will obviously have to be taken to the registrar, to the clerk of the court, or to the registrar first to sign the documentation, or to the typist, whatever the case may be. And a week later or so, depending upon the court's uh, how busy the courts are, or the typists are, capacity, the court you'll get a copy of the divorce order. So that's it in a nutshell how unopposed divorces work. I have a question online on the Facebook Live. If you marry income with your property, can individuals have their own will? Yes, you can for sure have your own will, but your will only be applicable to your half of the joint estate. That's very important to note. So if you are married, income with your property, and one party divorce, of course, the joint estate is now come to an end. There is no longer joint estate. Your half, your part of the joint estate will obviously can only be divided in terms of income with your property. That's how it works. So either in terms of a will, great. If you say my half goes to my kids in equal shares, simple as that. Or if you do not have a will, it will be intestate, and then that specific half will be divided intestate. So if you are married income with the property, out of income with the property, with or without approval, you can still have a will. But just remember, we'll only deal with your estate. So you married out of income with the property, without the approval regime, done. You stipulate whatever should happen to your specific estate. If you're married out of community or property with the accrual regime, obviously the accrual will first have to be worked out, given to the other side, or you must receive, I do not know, depending upon the facts, and that is how the estate will be divided. Okay, oh, the person says, yeah, thank you for that answer, my question on behalf of someone. You are welcome. I'm glad I enjoyed if people partake in these live webinars. So that's it for me today. The issue of unopposed divorces, quite simple, quite quick. As I say, the quickest we can get divorced, and if everything works out well and it wasn't COVID-19, would most probably be 21 days. Have a lovely day, and I hope to see you online again soon.